Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps to GDPR compliance. I'm Alan Calder, I'm the founder of IT Governance, and I'm your host this afternoon. My background is in general business. I've been involved in the world of data protection and information security since the late 1990s, when a business which I led then achieved for the first time a certification, first time in the world anybody had, to the forerunner of ISO 27001, that was BS 7799. And the book which I wrote about how to do it went on to become the Open University textbook, is now in its 6th edition, and indirectly gave rise to the creation and growth of IT governance, which now operates across pretty well every single country in the world. While our biggest footprint is in the United Kingdom, we've now got a subsidiary in Ireland which deals with our euro-denominated business across the whole of the rest of the other 27 member states of the European Union. We have a business in the United States, and we have operations in the Gulf and in Asia Pacific, and we provide a comprehensive range of services crossing information security, data protection, IT service management, all in the concept of a one-stop shop. And data protection has become a significant part of that activity over the course of the last 15 months or so, where GDPR, in terms of training, consultancy, books, tools, software, and a range of other support options, has become an enormously important part of the work that we do with our clients. I'm going to be talking today about the regulatory landscape, a brief introduction to that, and then I'm going to look over the principles of the General Data Protection Regulation, the breach notification rules, subject access rights, and of course, therefore, data subject rights, changes around consent, processor liabilities, the roles of the DPO, international transfers, and then briefly the role of the European Data Protection Board. I'm looking at this all from a primarily practitioner point of view, that what is it that you have to do in order to get the organization to a semblance of compliance by the 25th of May next year. And the webinar is being recorded for those of you who want to be able to access a copy of it afterwards. It'll be made available to everybody on the webinar and over the course of the next 3 or 4 days. If you find that as I'm going through the subject there are things that you want to ask about, please do use the questions function here in GoToWebinar. Type your question in there as soon as you think of the question. When we come to the Q&A session, which will be about the last 10 or 15 minutes of the webinar, then I'll work my way through those questions as quickly as I can. I'll start with the first question there is. I'll share the question with the audience and then tell you what I think the answer is. So that's the plan for today. We're going to finish at 4 o'clock Greenwich Mean Time. So let me start off just by a very brief overview for those of you who don't know your way around European legislation, by telling you that there are 2 different types of European legislation. The first is a directive, the second a regulation. Directives are in principle the European Commission telling member state governments what type of a law they have to put in place as part of their own national legislative structure, and what the minimum requirements of that law are. And it's up to each member state within its own legal structure to determine how it puts that into place. A regulation, on the other hand, is law. It doesn't rely on enabling legislation in member states. Member states might choose to put it in through enabling legislation, and if derogations are available, as they are with GDPR, that's one mechanism for member states to take advantage of the derogations. But essentially, a regulation comes into force as written across all of the European Union member states, and comes into force by virtue of the founding treaties of the European Union. So the fact that Britain has decided apparently to leave the European Union doesn't change the fact that until the point of departure, all of the EU regulations will come into effect in Britain, just as they do across the rest of the Union. So The existing data protection directive, which led to the creation of the UK's Data Protection Act 1998, is driven by a directive. The GDPR is, as the title suggests, a regulation. It comes into place on the 25th of May 2018 across the European Union. The fact that the UK is in the process of passing a data protection bill which incorporates GDPR and attempts to put in place, take advantage of the derogations inside the regulation, doesn't change the fact that the GDPR will apply whether or not that bill is passed. All the bill does, assuming it's passed, is give certainty to organizations and to data subjects that GDPR will survive the point at which Britain leaves the European Union. So the data protection model under the General Data Protection Regulation looks a bit like this. We are data subjects, natural living persons, and we have data, and we own our own data, and if we choose to hand it over to an organization that determines the means and purposes of processing would be defined under GDPR as a data controller. If we decide to hand our data over to the data controller, then it has obligations to us. Data controllers can, of course, while they'll mostly be legal persons, organizations, they can also be partnerships. It can also be an individual collecting data, running a business, perhaps on a self-employed basis. So a data controller is not by definition only a legal entity. It can be a natural entity as well, a natural person as well. Data controllers might choose to outsource some of their data processing to third parties. A data processor under GDPR is formally defined as an organization, a third party to whom some or all of the data processing is outsourced. So the logical assumption, therefore, is data controllers determine what they're going to do with data. They do it with data, and sometimes they pass some of that activity out to a third-party organization. When they do, that third party has obligations to the controller, and GDPR also allows for the transfer of data to third countries, recognizes that where they do so, the rights and freedoms of natural persons have to be protected, and recognizes also that data can be shared with third parties in just the same way as data can be obtained from third parties. So the existing landscape for how data is handled doesn't change much as a result of GDPR. What changes is the way in which the obligations of controllers and processors are set out, the activities which are necessary for them to demonstrate compliance and the penalties for failure to do so. The entity which supervises the GDPR across the United Kingdom is the Information Commissioner's Office. There are supervising authorities in each of the 28 member states, and the role of the supervising authority is to provide advice and guidance, but also to assess compliance and, where appropriate, to enforce it by means of instruction or monetary penalty or whatever seems appropriate. The European Data Protection Board comes into existence from what is currently known as Working Party 29, and the role of the European Data Protection Board is simply to ensure consistency in interpretation, understanding, and application of the GDPR across the 28 member states. So the structural logic is that it should be possible for a data subject to see their rights dealt with in exactly the same way in any one of the 28 member states, and for organizations or entities trading across the European Union to be able to demonstrate compliance to a single supervisory authority, what under GDPR would be called a lead supervisory authority, without having to comply with different variants of the regulation across all of the member states. So that's how the model looks under GDPR, and GDPR applies to entities that are collecting pretty well any data about people. The material scope is data that's processed wholly or partly by automated means, and or data that is part of a filing system or meant to be. By definition, therefore, it includes both digital and analog paper data. Data on paper records is subject to GDPR in just the same way as is a database. A Rolodex is a structured filing system. A pile of papers messed up in the corner obviously isn't. So the material scope is very substantial. The Persons whose data is processed in those ways have the right to their data to be protected, the right to protection of the processing of that data, and the right to free movement of their data within the European Union. And this regulation applies not only to controllers and processors based in the European Union, but also to controllers and processors outside the European Union if they are providing services into the European Union, or if they're receiving data from, i.e. in the form of a processor, from an organization inside the European Union. The test as to whether you have to comply is simply based on whether or not you're providing services into the European Union. And if you have to comply, it's possible that the definition of a data subject, it's not a European Union citizen, the protection is afforded to any resident of the European Union, irrespective of nationality or place of residence. If you don't comply, there are fines. You may have read about fines in the press over the course of many months. There are two levels of fines. Fines go up to 10 million euros or 2% of last year's global turnover for what you might call the lower tariff, and the higher tariff, which applies to breaches in respect of the 6 data processing principles, the breach of the sections concerning data subject rights and breaches around transport data processing. Breaches there can generate fines up to 4% of global turnover or 20 million euros. The operative word here is up to. The fines are meant to be proportionate. They're also meant to be effective and dissuasive. And it's clear that the extent to which an entity has been negligent in complying with GDPR is what will be taken into account in considering the extent to which fines are pushed up towards those maximums. So this doesn't mean that a fine is automatically going to be 2% or 4%. That's simply the maximum that it can be. And therefore, data controllers and processors should be thinking hard about what steps they can take to minimize exposure, to demonstrate that everything possible has been done to not be negligent and to meet the sometimes not very specific requirements of GDPR in terms of how personal data should be protected. Amongst the key definitions, though, is the definition of a personal data breach. It's set out in Article 33. It means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, etc. of personal data. Remembering that personal data includes anything that identifies a natural person, from biometric and genetic information all the way through to online identifiers and IP addresses. The accidental loss of a couple of personnel files would be a data breach, and therefore the obligations about dealing with data breaches would apply. Where there is a data breach, if you're a processor, and processors have to be processing data in line with a contract with a controller, a processor has to report that breach to the data controller within 72 hours, or as soon as you become aware of it. A data controller has to notify the supervisory authority also within 72 hours. The obligation to notify the controller does not apply if, in the judgment of the controller, having taken due consideration, there is no risk to the rights and freedoms of data subjects. If, on the other hand, there is a high risk to the rights and freedoms of data subjects, then data controllers not only have to notify the supervisory authority, the information commissioner, but also tell the data subjects themselves, all within a very short time frame. If you can't report a breach within 72 hours, you'll need to explain that as well. So the data breach reporting obligation, a significant obligation. Failing to report a breach itself will attract a fine, admittedly though, only up to 2% of global turnover. I imagine that saying you haven't reported a breach because you hadn't got round to working out what a good breach reporting program might look like could of itself be construed as somewhat negligent, but only time will tell. And that is, of course, true of all aspects of this regulation. It's a law, and that means that the final determination as to compliance or not is usually going to be made in a law court. While supervisory authorities will be able to find organizations in breach, organizations will be entirely within their rights to appeal those. Cases can be brought and pursued. It's a law. interpretation of what some of the phrases and terms mean will be determined over time in court. It's not yet clear, for instance, what the phrase taking account of the state of the art means in relation to assessing risk. And I'm sure that the next 10 or 15 years will generate interesting explanations of many of those terms. We're now very substantially through the transition period. The regulation was adopted by the European Parliament in April 2016, published in May 2016, and entered into force on the 24th of May 2016. There's a 2-year transition period. It applies from the 25th of May 2018 in all member states of the European Union. So we're now down to something just over 6 months left before GDPR will apply. And even though GDPR is suggested as being a bit of an extension and improvement on the existing data protection directive, the reality is that unless you already have a very well-established compliance regime that meets the requirements of the Data Protection Act, you're likely to have a very substantial piece of work to do to bring yourself into compliance with the regulation. Our experience across the United Kingdom is the Data Protection Act compliance is somewhat patchy, and that for most organizations the sheer volume of work that's necessary to get themselves compliant is sufficient to trigger the need for a specific, focused and properly resourced project to bring it about. GDPR starts, as I said, with the rights of data subjects, and the data controller, remember the data controller is defined as the entity who determines the means and purposes of processing. That's a very critical definition. The controller has to take appropriate measures to provide any information that the data subject might wish to see in a concise, transparent, intelligible, and easily accessible form. That means you can't hide information in complex legalese. It means that privacy notices, for instance, need to be made easily available, easy to be read in whatever the appropriate language should be. And more than that, you have to facilitate the exercise of data subject rights. Facilitate obviously means tell them what they are, but it also means make it easy for them to exercise those rights. We'll start with the right to have access to what you're doing with their data, the right to rectify errors, to have data which is no longer required for the original purpose erased, what's called the rights to be forgotten, the right to restrict processing while there is a discussion going on over the accuracy or otherwise of the data, rights to object to data processed under a number of circumstances, and of course the right to data being portable. The two new rights, the right to erasure and the right to data portability, are not absolute rights. They have conditions built into them, specific circumstances. So if you are looking at those, you need to bear in mind that there are, it's not an absolute right. It applies under certain circumstances. And finally, data subjects have the right to be informed of automated decision-making, including profiling, as well as the anticipated consequences of that profiling. If you're depending on consent as a lawful basis for processing, and I'll come back to consent, then data subjects have the right to withdraw consent at any time, and they also have the right to lodge a complaint with the supervisory authority, just as they have the right to bring an action in a law court for breach of the GDPR in respect of their human rights, their natural rights. Article 5 of GDPR, which is the article that comes immediately after definitions, so it's very paramount, says that controllers are responsible for and must be able to demonstrate compliance with paragraph 1, and paragraph 1 is the 6 data processing principles, and this we talk about as being the principle of accountability. In other words, organizations have to be able to demonstrate they are accountable for processing personal data in line with those 6 data processing principles. Those 6 data processing principles look quite similar to what exists in the Data Protection Act, except that there is a great deal more precision and a great deal more specificity behind each of the terms. So the first principle, the data must be processed lawfully and fairly, currently exists. The addition of transparent expands that principle, and there's a lot of very specific work sitting behind what, for instance, the word lawful means, and we'll come on to that also in a minute. Data must be collected for specified, explicit, and legitimate purposes. Legitimate has a specific meaning, as does explicit, as does specified. And frankly, if you're thinking about GDPR, every element of data that you collect, if you're clear about what the specified, explicit, and legitimate purposes are, then you will be quite easily able to make sure you're complying with all the other principles, which for principle 3 says the data that you've got must be adequate to the purposes which it was collected, must be kept accurate in relation to those purposes, must be retained only for as long as necessary for those purposes, and must be kept secure for as long as you have it. What you should see very quickly from this is that collecting data and retaining data in case you might need it at a later point is not going to fall within the range of grounds on which you can retain data. Once you've passed on from the point at which the data was required for the original purpose for which it was collected, you should no longer retain it. The Information Commissioner, in an interesting speech in January to the Institute of Chartered Accountants of England and Wales, talking about the principle of accountability, said explicitly, accountability is not about box ticking. It's not about just going through the motions of complying with GDPR. It is about putting in place a governance framework, comprehensive but proportionate governance measures that will build a culture of privacy that pervades an entire organization. She said accountability can't be bolted on. It has to be part of the company's overall systems approach to how it manages and processes personal data. And that's the context within which you should be thinking about the issue of reporting a data breach, an investigation that uncovers that you have avoided accountability, you've simply not addressed GDPR and the obligations to protect the rights and freedoms of natural persons in any significant way, is likely to lead to a fine being based on that area of negligence rather than on the minor issue which gave rise to the breach in the first place. So how do you apply this requirement for accountability? It must logically start at the board or at the partnership board, or whatever the senior management team looks like. There needs to be somebody in that senior management team on that board who is accountable for data protection, a corporate risk register which identifies both the risk to the organization and also the risks to the rights and freedoms of natural persons. And that then should drive how the allocation of roles and responsibilities through the organization operates, the extension not only to a data protection officer, but also to people in HR, sales, marketing, IT, finance, and so on, that they all have obligations in and around personal data. They need to understand what they're doing. They need to contribute to the organization meeting its compliance objectives. If that's effective, then they will be part of what you might call a privacy compliance framework, the link between how the board approaches its accountability obligations and the combination of the personal information management system, the PIMS, and the information security management system, which makes sure that you have both a data protection policy, you have a method of ensuring that data is being dealt with in line with the requirements of GDPR, and how you manage information security, the way you ensure that access, for instance, is limited to those who have a business need to access the data. You protect data from external intrusion, from accidental loss, and so on. You'll need records of processing. You need to set out, you need to describe what data you're collecting and processing, what the reason for doing it is, how you process it, how you protect it, any third parties involved, and you should be doing that now. You don't want to be writing up your description of processing after you've had a breach, because that'll be a little bit obvious. You'll need undoubtedly some method of responding to cybersecurity incidents, an internal response process, which should lead into a data breach triage process, which should enable you to determine not only what to do about the breach, but also whether or not it's something which needs to be reported. Turn to standards like Cyber Essentials and Cyber Essentials Plus in Scotland and the UK. Cyber Essentials is a government-mandated minimum basic cybersecurity standard. It looks at a whole 5 areas of technical security, such as around malware, vulnerabilities, and so on. And it's a minimum security standard. I would expect, and the Information Commissioner has said as much, that if you've had a breach and you haven't even bothered with Cyber Essentials, that would be a pretty obvious indicator of negligence. As the approach to GDPR matures, we expect to see the emergence of international and national standards which can be used to demonstrate compliance with GDPR, standards like ISO 27001, ISO 29151, and so on. And all of those are part of the shift that an organization needs to be demonstrating towards data protection by design and by default. It's a specific requirement of GDPR. The absence of data protection by design and by default can itself trigger fines up to 2%. And data protection by design is going to depend on a data flow audit, a data inventory, knowing what data you've got, how does the data flow, what are the ways in which data is used, who has access to it, and for particular types of processing, carrying out a data protection impact assessment. It's mandatory where you are monitoring data subjects on a large scale in a public space, mandatory where you're monitoring large volumes of special categories of data, and obligatory or mandatory where you're making changes to systems and processing, which is likely to lead to high risks to the rights and freedoms of data subjects. So data protection by design and by default, while it's a requirement, is something that in reality you might not be able to start addressing for a number of months. It's likely that there will be a number of other areas which need to be addressed sooner in your GDPR compliance journey. So moving on then on to Article 6. Article 6 deals with the lawfulness of processing. And in the UK, we tend to think of consent as the default basis for processing personal data. It's not logically the only basis on which you can process personal data. And in fact, if you think about it, it becomes clear that it's probably the least useful basis. It's the least useful basis because if you rely on consent, then lawfully the data subject has the right to withdraw consent. It has to be as easy to withdraw consent as it was to give it. That means that you need to have a box where somebody on the website can untick or tick to say I'm withdrawing consent, and you then have to stop whatever it is you're doing with their data. The consent to processing automatically confers the right to data portability and the right to be forgotten. Many alternatives exist inside Article 6. The first such obvious example is that processing could be in order to fulfill a contract between the organization and the data subject. That would be a much better basis for an employer-employee relationship. Employees, for instance, can't lawfully or validly consent to the processing of their data by the employer because, says GDPR, the relationship between employer and employee is unequal, and if consent is to be meaningful, then it has to be freely given. So there has to be no compulsion by the controller. Protecting the vital interests of the data subject is another reason why data can be lawfully processed, and the legitimate interests of the controller are also included. Legitimate interests include things like direct marketing. You do not have to have the consent of the data subject to involve them in direct marketing. You may have a legitimate interest in marketing to them directly. There are tests that have to be applied to ensure that is the case, but the reality is Article 6 sets out half a dozen lawful basis for processing data. You need for each element of data to determine what the lawful basis is, and you need to apply it. Don't select more than one because that puts you in a potential quandary where there is a breach and somebody's saying, well, no, I didn't consent at all. You're claiming I did, and the fact that you think you've got a second option doesn't get you out of trouble. For every data that you're processing, you need to have a lawful basis of processing by the 25th of May next year. GDPR doesn't apply for processing that you do after that date. It applies to processing you do on that date and thereafter. And all the data which you currently have on your systems is data you're currently processing. So by the 25th of May, you need to have got to the point where that data is being processed lawfully. It should be obvious, but if you don't have a lawful basis for processing it, it's illegal to process it. So Between now and May, that's the slightly less than 6-month period, you need to make sure that there's a proper lawful basis and the data subjects are aware of what that lawful basis is. GDPR clearly distinguishes for the first time in law between controllers and processors, clearly identifies obligations of both. Processors are legally only able to process data in line with a contract from a controller. And so part of your GDPR compliance project is necessarily determining whether in relation to each element of data, you're a controller or a processor. You don't want to leave that to chance. If you think you're a processor and you haven't identified a controller with whom to enter into an appropriate contract, it might be that you're actually a controller. The obligations on both entities are different, and it's a key area in which you need to make sure you're compliant. Where you do rely on consent, and as I said, it should be the fallback option, not the primary option for a lawful basis of processing, consent must be clear and affirmative. You must be able to demonstrate that consent was given. It's no good just saying, yes, I'm pretty sure she said that we could do that. You need to be able to demonstrate it. That might mean you need to record the data. You might need to keep log records of somebody ticking a box. Consent by default will be illegal. It'll no longer be lawful to have on your website, for instance. We will continue to send you marketing email unless you untick this box. That's called consent by default. It's not positive consent. Consent has to be signified by a positive act, ticking a box, changing browser settings, or something like that. As I said, having given consent, you have to be able to withdraw it as easily as you gave it. People under the age of 16 are prohibited from giving consent to the processing of their data unless a member state derogation is in application, is applied. Member states can determine the minimum age at which children consent all the way down to 13 years old. Below 13, and if the member state hasn't chosen something below 16, whatever the age is, children may not lawfully consent to the processing of their data for an information society service. It doesn't, in other words, affect any other services, any other contractual things that data subjects that the children might do if there is a legal right for them to do it. All it says is that they can't open a Facebook account or a Tinder account or any one of those accounts without the official formal approval of their assigned adult. So that means that whether that's a parent or a guardian, and the organization offering the service will need to have an effective mechanism for ensuring that that consent is given not by the child's friend, but by a proper, genuine, real, live adult. So the obligation on organizations to make sure that where it's likely that their services will be accessed by children, they have a mechanism for properly establishing consent is a significant challenge. There's also a shift around the processing of special categories of data. Special categories of data include information on race, gender, biometric information, genetic information, trade union membership, political beliefs, and so on. GDPR says that processing that data is prohibited. It's not just it's allowed as long as, but it's prohibited unless you can identify a specific exception which enables you to do so. And if you're looking to process special categories of data, it means that A, you need an Article 6 lawful basis for processing, and you also need an Article 9 exception, which enables you to process that. The most common exceptions will be vital interests of the data subject, or it will be the explicit consent of the data subject, or it will be data necessary for the performance of a contract between you and the data subject. So, as I said, Articles 6, 7, and 9 all work together very specifically, and you need to make sure that there, and Article 8, which deals with children, you've dealt effectively with consent if you're relying on consent, and particularly you also need to think about special categories of data. Articles 12 to 18 then talk about transparency, which we met early on in looking at the first data processing principle. And Articles 12 to 18 go into more detail about what the requirements are around transparency. And in simple terms, what they're saying is that all communications must be concise, transparent, intelligible in the language of the data subject, use pictures and icons and graphics wherever that will make the message clearer. Don't rely on complicated legal statements. and give them the information about their rights and about what you're doing with their data if and when they ask for it. You need to have a good data subject access request process. You've got 1 month from the date on which they ask for their data. They don't have to do that in writing. 1 month from when they ask for their data to give it to them. And yes, they can ask for data which you are holding in your archives. They can ask for data which you're holding in your backup tapes. All of that is information which they're entitled to ask for because you're processing it, and therefore it's their data. That's one good reason to make sure that any data you're holding, which is beyond the date that you needed to hold it, is deleted, expunged from your records. I did mention data protection by design and by default. This is covered in Articles 25 and those that follow. Essentially what they're saying is that data protection needs to be designed into your processes. If you've got a new IT project or a new business project running now that's likely to come into place somewhere in the next 6 to 9 months, it would be smart to build GDPR thinking into the design and development of that process right now, so that you don't then have to try and bolt it on later on when that process or project or system goes live. Controllers and processors not in the European Union must designate a representative inside the European Union. That representative is an entity to whom a data subject can bring a case or with whom a supervisory authority can liaise. But the appointment of a representative, of course, does not absolve the entity itself from its obligation to comply with GDPR. Touched on data protection impact assessments. Data audits are a logical follow-on from that. There is a requirement in GDPR that organizations ensure on an ongoing basis that they comply with GDPR. In other words, GDPR compliance is a journey, not a destination. It's not something where you go, if I've made it by the 25th of May, I'm okay, I can forget about it, don't have to worry anymore. It's a compliance regime which applies to the organization forevermore. In much the same way as in many countries, health and safety legislation has become a core part of how organizations think about how they look after staff, for instance. So GDPR comes into the same frame. The sixth principle talks about protecting personal data. Article 32 goes into quite a lot of detail. The requirement is that data should be protected, processed in a way that ensures appropriate security of the personal data, including protection against a data breach. Appropriate is not defined. That means you need a mechanism for defining appropriate. Typically, that's in the form of a risk assessment methodology. And then you need to be able to determine appropriate controls, and appropriate controls could stretch from pseudonymization or encryption of personal data all the way through to the different steps that you might put in place through training of staff, through access control systems, through supervisory, through monitoring of people, to ensure that personal data is accessed only by those who need to access it and is protected from unauthorized access, unauthorized attacks on its integrity or confidentiality. I did already talk a bit about certifications. More and more we'll see international standards and certifications against those standards coming into place as a mechanism for organizations to demonstrate that they've done everything within their practical power to meet the requirements to put in place an appropriate method for protecting the rights and freedoms of data subjects. So the privacy compliance framework, as I mentioned earlier, and as you can see now in a bit more detail, really should link the accountability framework, how the board is dealing with its obligations around governance, risk management, and compliance with the policies, procedures, controls, and records of compliance with those procedures that deliver on the 6 privacy or data processing principles. Data Protection Officer is a role which is clearly set out in GDPR. It's a mandatory role for people in certain types of organizations. It's usually those organizations processing substantial volumes of personal data or special categories of data, where that's part of their core activities. And the appointment of a DPO in those instances is mandatory. You have to have one. A DPO is somebody who has to have both a good understanding of law and of the privacy legal frameworks, as well as a good and practical understanding of cybersecurity, incident reporting, data breach reporting, the whole range of issues which are part of ensuring that you can give an organization good, straightforward advice on how to meet the requirements of GDPR. Data protection officer's role is protected in a couple of ways. Firstly, the DPO cannot be somebody who has an existing role that will conflict with the obligations of being a DPO. So if somebody has a role which in an organization involves them in determining the means or purposes of processing, they can't also be a DPO. They have a conflict of interest. DPO's role is also protected in that they can't be dismissed because you don't like their advice. They can obviously be dismissed for any of the normal disciplinary reasons. They keep turning up late, they misbehave, but you can't dismiss them because you don't like their advice. It's likely that DPOs where you don't like their advice and don't take their advice will find themselves increasingly obligated to report that to a supervisory authority or possibly simply to resign. But it'll be a very difficult position for a DPO to be in, where they tell you that you need to do X and you determinedly do Y. Outside of the mandatory appointments, it'll be increasingly a good practice appointment. The reality of compliance with the GDPR and the fact that the detail of compliance will continue changing for a number of years is likely to mean that many organizations will appoint a DPO either on a full-time or a part-time basis, and you can appoint a DPO on a contract basis, not just simply as an employee. So you can have data protection officers who work for you on a DPO as a service basis, so to speak, where you get 4 hours a month or 10 hours a week or whatever is appropriate for the organization. You obviously need to extend training not just to those who have specific obligations, heads of HR, sales, marketing, finance, and IT, but also you'll need to make sure staff generally are trained around data protection and their obligations around personal data. Certifications I've talked on. We'll see more and more standards, more and more certifications, more and more seals emerge, which will cover different aspects of ways in which organizations can demonstrate compliance with the requirements of GDPR. Whatever emerges, however you use those, there will be ways to demonstrate that you've not been negligent. They won't, however, absolve you of the need to comply and won't necessarily be proof that you are in compliance. Simply, they'll be proof that you made best efforts to comply. Then there is international transfers, finally, from the point of view of compliance. The requirements are slightly more detailed and extensive than under the Data Protection Directive, but essentially you can't move data outside of the European Union or outside of the European Economic Area without being able to meet one of three basic standard tests. The first is that the country to which you're moving the data has been judged as having an adequate data protection regime, and that's an European Commission decision. It only applies to about 10 countries around the world. In the absence of an adequacy decision, you can rely on appropriate safeguards, which are typically standard contract clauses between you and the organization to whom you're transferring the data, which you need to be able to enforce. You need to be sure that the rule of law is such that you can enforce those standard contract clauses. And for international organizations, binding corporate rules, again, a mechanism which enables an international organization amongst its own internal entities to enforce a particular set of rules around data protection. The United States doesn't meet the adequacy requirements. There's no adequacy finding in relation to the United States, which means that passing data to the US other than via standard contract clauses or binding corporate rules is impossible, which is why the safe harbor arrangement was put in place. The safe harbor arrangement was pulled down in April 2015 and replaced in July 2016 with the EU-US Privacy Shield. The latter is a fiercer form of safe harbor, but essentially for those United States organizations which register under the EU-US Privacy Shield, they're effectively laying claim to being in a regime which meets the European Union's adequacy requirements. And so an organization that is Privacy Shield registered can receive data from entities inside the EEA. Member states have to have their own independent supervisory authorities. As we've seen, that's going to the Information Commissioner in the UK. Their tasks are to monitor compliance, communicate, promote awareness, but also to investigate, correct, advise, and enforce. And you can select a single, as an organization, supervisory authority to handle your GDPR compliance requirements across multiple member states. The fact that the lead supervisory authority has to be that of a member state means that beyond Brexit, choosing the ICO at the moment looks as though it's an impossible option. So if you're providing services into the European Union as a UK company, beyond Brexit, you'll need to be thinking about choosing a lead supervisory authority somewhere in the European Union, part of your longer term strategic thinking. Of course, it's possible that some other solution will emerge in the meantime, but it might not. The European Data Protection Board, as I've said, its role is really to ensure a level playing field across the 28 member states to ensure correct application of the regulation and deal with any questions that come up that means that there might need to be guidance or clarification, which can then be applied consistently across the EU. So the Information Commissioner's final words in that speech I mentioned earlier on were that accountability, yes, is expensive. It's an upfront investment in privacy fundamentals, but it ought to give those organizations who recognize that it's a good thing to do a competitive edge. It should enable them to set themselves apart from those competitors who see protecting the data of their customers and staff and suppliers as a lesser priority. It should enable you to compete effectively with them. However, says the Information Commissioner, if that's not what you choose to do, the GDPR has given us a big stick. The evidence is already clear that we're happy to use the much smaller stick that we have under the current powers given to the Information Commissioner to enforce the Data Protection Act, where we can levy fines only up to £500,000, and where our biggest fine has only been £400,000. So given that we'll do that, the Information Commissioner didn't quite say the biggest fine we're likely to levy is 80% of 20 million euros. We don't know what will happen, but the reality is that regulators have the power to deal with breaches of GDPR, and you now have to tell them where that breach of GDPR has led to a data breach. You can't hope that nobody will find out, and you're also at risk from data subjects who decide that the way you have dealt with their data is wrong and who bring a complaint to a supervisory authority or who decide to sue you in a court. Any one of those simple actions could lead to something much more significant. So 9 steps, we think, to GDPR compliance: put in place a governance framework, make sure the board is properly engaged, appoint and train a data protection officer or a senior data protection officer, build a data inventory, identify any processors with whom you're sharing data, identify any unlawfully held data and get rid of it, do a data flow audit, make sure you've identified what's happening with personal data, analyze your compliance gaps, make sure your documentation, data subject access requests, privacy notices, and so on are all robust, legal, GDPR compliant. Develop records of processing. Where necessary, do a DPIA for critical processing, do a security gap analysis, and remediate. Build your privacy compliance framework. Look at security certifications like Cyber Essentials at ISO 27001. Build your incident response and data breach reporting capability. Do test it. Don't wait until you have a breach before you test it, because that's the wrong time to discover it doesn't work properly. You've only got 72 hours to report a breach. And then get into the habits of monitoring, auditing, and continually improving how you do data protection compliance. However far you get by the 25th of May next year, it's unlikely that you will have succeeded in embedding data protection by design and by default. You will, with a bit of luck, have made significant progress towards something that resembles compliance. It may take another 6 to 12 months to embed into all of your processes data protection by design and by default, and being able to point out to a supervisory authority that you've taken appropriate steps is really where you want to be. As an organization, IT governance can help in a number of ways. We have books and pocket guides that give guidance on how to tackle it. We have a documentation toolkit, which can take something like 60 or 70% of the effort out of creating GDPR compliant documentation. Why start with a blank piece of paper if you can start with a template and adapt it? There's a gap assessment tool which enables you across the 10 key areas of compliance to see where your gaps are and what you need to do to be sorting them out. There's a set of internationally accredited training courses at foundation practitioner level, as well as a data protection impact assessment workshop. And those are delivered in the classroom, online, through distance learning, or in-house to organizations who have a number of people who want training. And of course, there is a substantial range of available consultancy services, from gap analysis through data flow audits, helping put in place personal information or information security management systems, cyber health checks, and of course a data protection officer as a service, offering a whole comprehensive range of things that can help you in your GDPR journey. That brings me to the end of what I'd planned to say, and so in the remaining 10 minutes, I'm going to start dealing with those questions where there are questions. Just to remind you, if you have questions, please type them into the questions box on the GoToWebinar panel. I'm going to start at the beginning. I'm just simply going to read out the questions that there are and then tell you what the answer is. So the first question is, GDPR cover bank details, financial data, tax details, and NI numbers? Yes. Anything that can identify a natural person is personal data, and therefore it's caught by GDPR. Anything. We require doctor's notes to prove sickness under the GDPR. Do we require to get explicit consent, or is this under contractual agreement? It will depend. Health information is likely to be a special category of data. It depends on what you're looking for in the way of a doctor's note. If the doctor's note is simply a fit note saying the person is fit to resume work, I suspect that you're going to be able to avoid treating that as a special category of information. If it's more extensive information that tells you what the state of health is, then I suspect you're going to rely on explicit consent, not least because the medical practitioner is likely to have sought the explicit consent of the data subject before they will even share the information with you directly. Should IT technicians have access to everyone in the organization's passwords? Absolutely not. Never. Passwords should be known only to the person who uses that password to authenticate themselves. If an IT technician has access to a user's password, it enables them to log on as that user and authenticate as that user. It means they can do whatever that user is entitled to do, and the logs will demonstrate that the user did it, not the IT technician. Passwords should be confidential, should be encrypted. There should be absolutely no possible way that IT technicians can access those passwords. It's not just a breach of GDPR, it's frankly a breach of basic information security practices, and that will get you into trouble on just about any regulation you can think of, just about anywhere. Are individuals within companies covered? So obtaining a CEO's email address from a business card or via referral, and then adding that address to the email distribution list. A company email address identifies a person. Alan Calder at itgovernance.com is personally identifiable information, so it's protected by GDPR. The fact that you find it on a business card doesn't alter it. What you have to do under GDPR is tell me that that's where you found the data. Article 14 requires you to issue a privacy notice that tells me where you got my data from and what you're planning to do with it, and you have to give me the right to object to that processing. So yes, you can take my name, email address, business email address off my business card, put it in your CRM system. Before you do anything with it, you send me an Article 14 privacy notice, tell me how I can object to the planned processing, and then act on whatever my objection might be. I would like some advice on establishing binding corporate rules for international transfers. The practitioner advice you can get from our consultancy team, the legal advice you'd get from a firm of specialist lawyers. As company IT governance are practitioners, not lawyers. We work happily with legal teams wherever clients need access to specific legal advice. are cookies and recoding browsing history on a website addressed under GDPR. The upcoming e-privacy regulation will specifically deal with cookies and remarketing, but the GDPR link there is that anything which identifies a person, and I think arguably a cookie placed in a browser identifies a person, it's a mechanism for tracking that person, is captured by GDPR, and nothing stops you from placing a cookie in a browser as long as the data subject knows and accepts it. And one of the changes will be that you can't just simply rely on the fact that you've provided a notice. People will have to positively accept. The other options than consent are listed in Article 6. Is anonymization of personal information acceptable as a means to being forgotten? No. Anonymization is a different step. Anonymization effectively makes it impossible to identify the data subject from the data, and it therefore removes the data from the scope of GDPR. Remember, within scope is anything that identifies a person. Anonymized information means you can't identify a person. The rights to be forgotten means the removal of the data. And technically that means simply deleting it, making it no longer there. It'll be interesting to see sooner or later, I'm sure there will be a court case which says anonymization is a good way of making that data not available, and I don't know how that's going to pan out. Overwriting first name, last name, and all personal details is removed by request. You're going to have to look, is the simple answer, at how that works inside your own database. The requirement is that you stop processing the data if that's what the data subject asks you to do, and you're going to have to find a technical solution that enables you to avoid destroying the data. But if, frankly, the links between that person's data and other elements would enable you to identify the person, arguably you might still be identifying the person. So you're going to have to look at that in a bit of detail. Yes, an employee can withdraw consent to their contract of employment. It leads to lots of problems. That's why between now and May, you need to talk to all of your employees and give them a different lawful basis of processing, not consent. You need to tell them here is a change to your contract of employment, which enables you not to rely on consent, which in any case is not valid. What should organizations do where they do not have evidence of privacy notices being issued for data collected prior to GDPR coming into force? Well, you issue privacy notices now. All you have to do is be able to demonstrate the processing is compliance with the GDPR. And obviously, prior to GDPR coming into force, you wouldn't have known what the requirements were. So you might have collected data 10 years ago under a very different regime. You can still retain that data. All you have to do is comply with GDPR in respect of it. You have a legitimate interest, I suspect, to continue processing it. And so you need to say to the data subject, here's a privacy notice issued under Article 13 of GDPR, telling you what we've got in the way of your data, what we're doing with it, what our legitimate interest is in doing it, probably direct marketing, and how you can object. I believe there is an exemption if you have under 250 employees. Is that correct? So there is an exemption, or a derogation rather than an exemption. The derogation is that if you have under 250 employees, you can effectively have much less in the way of documentation than otherwise. And that much less is if there is no risk to the rights and freedoms of data subjects. So you've got to go through the process of determining whether or not there is a risk to rights and freedoms. And if there isn't, then you can decide not to put in place the more extensive documentation that might be necessary if there is a risk. Exactly how that's going to play out, we don't have any formal guidance yet. I struggle to see how you can be processing personal data and there are no risks to the rights and freedoms, other than if all of that data is encrypted all of or most of the time. As a company, I only process payment data and my lawful basis is contractual. How do I move on? I don't think you need to. You do not need consent, no. Can I find samples of contracts compliance GDPR? It depends entirely on people being prepared to share samples of contracts. And given that GDPR doesn't apply yet, nobody really knows for sure whether a contract is compliant until it gets tested. All we as practitioners, and I'm sure all lawyers are saying, is this is what our best guess is as to what compliant looks like, and let's hope it works. The practical reality is likely to be that unless someone brings a complaint or you suffer a breach, you may not have whatever your steps are tested for some time after the 25th of May. I cannot tell you if India is being assessed or is likely to be approved under GDPR. No, I would think the working assumption has to be that there is no adequacy finding in respect of India, and those bleeping noises are to tell us all that 4 o'clock has arrived, which means that I've really only got time left for one single answer. And I'm going to take this question here, which is, can you further explain how legitimate interest can be used as a basis of direct marketing? And can legitimate interest be used for executing marketing campaigns with third-party purchase data? So there are two questions. You can still purchase data from third parties. You can acquire data from sources other than the data subject. You'll want to make sure that the source from which you've got it legally has that data. And before processing the data, you will need to issue an Article 14 privacy notice to data subject saying this is where the data came from and this is what you plan to do with it and how they can object. That's the answer to the second question. The answer to the first question is that legitimate interests are defined in GDPR and in its recitals, and direct marketing is identified as a legitimate interest. And having been identified as a legitimate interest, and the tests for what legitimate interests are also set out, you need to go through a process of saying this direct marketing activity that I want to carry out, is it appropriate for the data subject? And a simple way of thinking about that might be, if a data subject got information from us about fridges, then we've got a legitimate interest in sending them direct marketing in relation to fridges and fridge-related services, but almost certainly not in relation to holidays in the Antarctic. So, ladies and gentlemen, I hope that's been a useful webinar. I'm afraid we are out of time. Many of the answers to these questions are already available in one form or another in the FAQs, and we'll be circulating this webinar and where we can, answers to the questions over the course of the next couple of weeks. Thank you very much for being here. We'll be rerunning this webinar on a fortnightly basis over the next few months, and in parallel there are a series of, again, free webinars being run for those of you who want to find out more about particular aspects of GDPR compliance. So thank you all very much for being with us today, ladies and gentlemen, and good luck on your GDPR journey over the slightly less than 6 months that we all have left. Good day.